everyone. I hope you're doing well today. We've got some really interesting court cases on the docket. Ha ha ha, as it were. Some of it is definitely stranger than fiction, so hang on to your hats. First and foremost, we're going to be looking at how the Supreme Court has attempted to balance individual liberty and public safety. Some of these might not sound like such extreme examples, but I'm going to also give you some of the history of the time period, which will help put some things in perspective. Because remember, our Supreme Court is definitely influenced by the society and culture of the time. So, our first case that we're going to be looking at is Gitlow versus New York. This is from 1925. I do want to take note really quickly that this is not a required case, according to AP College Board, but it is one that does a really nice job of explaining or providing an example of this balance. We talked about skank last time, and you'll notice in the rationale here that this is pulled up as a precedent in order to make their decision. But ultimately, it's just a great example, like I said, of how the Supreme Court has dealt with these limits to free speech. So Gitlow is a socialist, and I'd also like to point out that although this sometimes gets thrown around as a dirty word, during this time period, you'll notice 1919, around the time of World War I as well, there's actually a huge socialist movement happening around the world. So it's not just when we're thinking about, oh, Russia, that's their thing. There's a lot of famous people, both closer to home and maybe even ones that you didn't know were part of or members of the Socialist Party. So I'll just give you a little interesting fact here on the next slide, and we'll come back to this. If you've never seen this before, it's actually a mural, and it was designed by Diego Rivera. He was a socialist activist during this time period. It was actually designed around 1933, and he came to the United States in order to produce it. It was originally meant to be in the Rockefeller Center in New York, and the Rockefeller family had okayed it. But actually, as time went on and they saw the piece, they decided that it was anti-capitalist propaganda. And you'll also note that there's a tiny little picture of Lenin in there. And the Rockefeller family said that there was no way they were going to allow a giant mural in the Rockefeller Center in New York City to feature Lenin. Just a little bit of interesting tidbit there. This mural no longer exists. It was destroyed, although Diego Rivera did redo a similar piece. This is kind of a copy of what it would have been like back in his hometown in Mexico. Another famous socialist who was active during this time period was Helen Keller. A lot of people know her, but are unaware that she was actually a prominent member of the Socialist Party. So I just want to put in perspective that Gitlow isn't just a crazy socialist wandering around New York City. There's lots of other people wandering around that have some similar ideas. But what he was doing was distributing what we would call a left-wing manifesto. And what's important is that he was asking for the populace to violently overthrow the government. So New York has a criminal anarchy law, and he was convicted under this state law. And ultimately, it did go to the Supreme Court. You'll notice here that the question falls under the First Amendment, and we're asking whether or not the First Amendment can prevent a state from punishing political speech, right? And ultimately, the Supreme Court decided that, yeah, the state could prohibit any kind of free speech that would overthrow the government. And this is really interesting too, because if we're thinking about skank, right, they decided to preserve the social order or public safety, and instead of defending free speech, because skank, right, ultimately did get in trouble, and they said that no, the government has a vested interest in potentially needing to raise an army, and so we have to prioritize that public interest over individual liberty. And that's the same thing that happened here. And this is also important because we have the dissent. You'll notice the clear and present danger test. So on the other side here, right? They're saying that no, he did not violate it and it's just an abstraction. But this is where we have that push and pull. And we might consider that perhaps because there's this growing socialist party at the time, there's a genuine fear that the government would get overthrown. So this is where they have prioritized the public safety, public need over free speech. There it is. I think it's pretty cool, actually. Okay, now everyone's absolute favorite Miranda rule. I always like to ask who in the class can actually say the entire Miranda rights. And of course, it's been made famous by 21 Jump Street at this point. But if you didn't know the history of the Miranda rule, it gets even crazier than you might have ever assumed. So, this is a copy of the Miranda warning. If you're a person who enjoys watching crime dramas or British crime shows like me, you'll notice that the UK has something similar. We're going to dive into that when we do comparative government next semester. But ultimately, what this means is that anytime a person is arrested, they need to be made aware of their rights. And also important here, when we're talking about criminal cases, about 90% of cases begin with a guilty plea. And then thinking about your crime dramas, why do lawyers actually pursue then bargaining? It saves time and money because anytime you're going to trial or going to court, it's going to cost a lot of money. And then another interesting piece here, just to kind of lay it out explicitly, if we're talking about the Bill of Rights, which we have been during this unit, the 4th, 5th, 6th, 7th, and 8th Amendments all have to do with rights of the accused. So think about, why is that? Our current legal system is kind of a brainchild based on common law in England. But again, it's been created especially with the Bill of Rights and the rights of the accused in order to prevent that tyrannical government from crushing the individual. But what's also interesting here, and some people have, what's the word I want to say? Accused our legal system or our justice system of protecting the criminal more so than the victim. Food for thought, something to think about. All right. So here's another one of our cases. We're going to get into some more stuff with Miranda here in a minute. But in New York versus Quarles, and this is where I want to bring up the exception, public safety exception. Essentially, an individual was in a shopping market. A police officer entered him, saw him, asked him to stop, searched him, did find a weapon, even though the weapon was not loaded, and then later read him his Miranda rights after search and seizure, essentially. So in this case, we want to know if basically Quarles' statement about having the gun and even the fact that he had the gun on him should be thrown out because he hadn't read Quarles' Miranda rights at that point in time. So remember, he did it after he searched him. And this is where, again, we're talking about that balance. So they're saying no because there's a public safety element or exception, right? So if there's some kind of issue that needs to be addressed immediately, the expectation is that it's going to be addressed immediately, and it shouldn't it didn't fall then on, in this case, the arresting officer, right? He had to act in order to protect the public. So something interesting to think about there. Dun, dun, dun. Moving forward, we're going to look more at the rights of the accused, but also this concept of pre-trial rights and the prohibition of unreasonable searches and seizures. This is one that I find that students always ask me about. They're like, can you really get in my backpack anytime? Well, yes or no. Yes and no. That's a complicated question too. All right. So here are the rights of the accused. And I'm just going to throw in a little pop quiz. Where can we find these rights in the Constitution? So they are guaranteed. Where are they? Ding, ding, ding. Okay, if you said Sixth Amendment, you would be correct. So legal counsel is ensured by a previous court case, Gideon versus Wainwright. We're going to look at that in the next few slides. The speedy and public trial. This is interesting because we do have overburdened court systems, and so speedy is definitely a relative term. But the reason why we came up with speedy and why the framers were concerned about this language is that essentially they didn't want a person to just be sitting in jail or in prison waiting for a trial, right? Because that was seen as inhumane. And it's basically like you're locking somebody up without actually giving them access to that trial. So it goes both ways. And then impartial jury. This is also a tough one too, because as you probably are well aware at this point, we haven't always been a perfect society. And especially in the South, there's a really, really long history of all white juries. And that makes sense because if we're talking about post Civil War, Jim Crow, there were a lot of restrictions on making sure that minorities and Black Americans were actually registered to vote. And when you're registered to vote and have those kinds of privileges, that's what also allows you to serve on juries. So you can see where the problem lies. Essentially, it's a it's a self-defeating cycle. Okay, so here it is: Gideon versus Wainwright. Dun dun dun. This is the case that sets up the right to any attorney, no matter your individual circumstances, and with any case. Okay. So essentially, this gentleman was charged for breaking and entering, so he did commit a crime. Um, but when he asked for a lawyer, they told them no, or excuse me, they told him no because it wasn't a capital case. And so this is important because remember, this is happening at the state level. So this is Florida state law. And ultimately, he didn't have the funds to actually hire a lawyer. And he chose to represent himself, or excuse me, chose is a strong word. He lost and attempted to have his case overturned. It took him quite a while to actually get to the level of the Supreme Court. And what he ultimately did is while he was in prison, he filed an informa pauperis brief with the Supreme Court. And what this is a procedure in the form of a pauper available to those who believe they were wrongly convicted and do not have the means to appeal through the typical channels. The court actually receives thousands of these every year. And every now and again, they pick one that they feel is worthy. And this is definitely one that felt worthy because from this particular case, now we make sure no matter who you are, where you come from, what the case, you have the right to legal counsel. And so we're talking about the Sixth Amendment here, our rights of the accused, and we're asking whether or not the Sixth Amendment extends to criminal cases and in state courts specifically. And so ultimately, the Supreme Court decides that yes, right, this is something that will extend to those lower level courts and to criminal cases. And this is also guaranteed by the Fourth Amendment, right? The due process clause and equal protection under the laws. Super interesting. All right. Did I go forward? Okay. But there is something known as the exclusionary rule, which is also important. Um, so in Mapp versus Ohio, this one comes up very often. It's not a required case either, but it will be relevant, and you may find that it might come up just in reference to other cases as well. So this is the 1961. Ultimately, what happened is the courts are deciding when to apply the exclusionary rule. And unfortunately, they kind of launched themselves on this path that they've not been able to recover from because now it's kind of a push and pull between when that is actually going to be applied. So this person, Dalry Mapp, she was convicted of possessing obscene images and materials. She allowed uh, police to search her home, um, but then they weren't looking for those images, they just happened to find them, and so in this case, uh, they're looking at whether or not those confiscated materials are protected by the First Amendment. And then again, they kind of brushed the First Amendment aside and went more with the Fourth Amendment in this case, and that if you're not going through the proper channels for searches and seizures, right, they're violating that Fourth Amendment, then ultimately it is inadmissible. All right. And then I wanted to go back because I promised you guys a juicy story. Dun, 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 if I can get back. So we introduced the Miranda rights, but just as a little extra tidbit, uh, this is one of the most interesting cases afterwards as well. So I thought I'd give you a little extra fun knowledge. So ultimately, after Miranda's case was overturned by the Supreme Court, and he had committed those crimes, so he was actually convicted on kidnapping, rape, and armed robbery. And this was based on a confession that he made while under police interrogation. Um, but what happened is that he was not Mirandized essentially before the interrogation. And this made it all the way to the Supreme Court. And ultimately, like we said, the Supreme Court said no, he needed to be made aware of his rights before being interrogated. And so essentially, then the Supreme Court invalidated his confession. So he did go back to Arizona, and Arizona did retry him. At the second trial, they couldn't use the confession, so they did not introduce it into evidence at all. He was convicted again in 1967, and this was actually based on testimony given by his estranged common law wife. He was sentenced to 20 to 30 years in prison. He was paroled in 1972, and after he was released, because he had all of a sudden become famous, right? Everyone now knows them as Miranda rights. He would sell autographed Miranda warning cards for $1.50. He had several run-ins with the law over the next several years. He even went back to prison at one point for violating parole. And then in 1976, after being released again, he was in a bar fight in downtown Phoenix, and there he was stabbed. He was pronounced dead at the hospital once he got there. He did have several of his autographed Miranda cards on his person. And here's the most interesting part about it. The person who was suspected of handing the knife to the man who murdered Miranda actually invoked his Miranda rights and refused to talk to the police. The person was released and never charged with Miranda's murder. So the killer fled and was never found. Dun dun dun. Strange, but true. All right. That's all I got for today. Let me know what you need, and I will talk to you again soon. Bye.